The Honourable Trevor Mallard.
Well, this is the point. This is the point. I thought it would be good. I know that we've gone beyond clause 24 now, but luckily I've been looking very carefully at clause 68, which is a validation of irregularities. And the validation of irregularities, clause 68, refers back to clause 24. And therefore, I thought it would be a good idea for the members who earlier in the debate pleaded that they did not know what a facsimile machine was, that I would find one for them and I would bring it. Now, to be absolutely fair, I could be just about accused of trawling through the rubbish to get it. I found this in a pile of things that were heading towards the rubbish that have been sitting outside a member's office for some time. So for members around the House who are not aware of what a facsimile machine is, this is one of them. I'm not absolutely certain, but there are plugs which go into a telephone line. I think to be absolutely fair, this is a modern version because it can also act as a photocopier. One of the more modern machines around, no, there was no carbon required in this photocopier facsimile machine, and in fact it will work with things which are written on golf ball typewriters, as well as the old imperials that most of us use two fingers for.
Cars smaller than that.
Now. So just for, and I'm looking at the members. Other than my colleague, the Honourable Ruth Dyson, who I know is above 40, I think there are hardly any other members on the Labor side of this House would have been within their working lives involved in jobs where facsimile machines were still technology that was used. This is what one of them are, and I'd like to bet that there's not many people on Rail Island use them anymore. There's not many people on Rail Island use these, and on ships, of course not. Because clearly, if you can get through to a ship, you can get through by email. If there are, if you've got the technology to get there by telephone line, or not line, obviously with a ship, by telephone and remotely, then these can be used. And so, but the interesting thing was, Mr. Speaker, in trying to work out how I could get the facsimile machine into the debate in a proper way, it caused me to look very, very carefully at clauses 67, but in particular 68. And I want to say, Mr. Chairman, this clause is an outrage. This clause is an absolute outrage. What this clause effectively does, especially in 68(3), under a claim to validate irregularities, it allows the Governor-General, on the recommendation of the Prime Minister, to make such other provision for the case as the Governor-General thinks fit. Now, I want to ask Dennis O'Rourke down there, remembering the Governor-General has to act on the advice of the Prime Minister, if the Prime Minister says, I don't like the result of the referendum, is it within bounds of the Governor-General under 68(3) on the dictation of the Prime Minister to override the Act and to change the result? I know Mr. O'Rourke's a lawyer, but I just want to ask people to look really, really carefully at 68(1) and ask what is a fundamental constitutional question, and that is whether primary legislation should be overridden by regulation. The member, Chris Bishop, says yes. Chris Bishop says, yes, that is a good approach to legislation. Well, I just tend to differ. I tend to differ with Chris Bishop on that. All of the constitutional arrangements I've ever understood said that Parliament made the law and regulation was subservient to that. and that regulation, secondary legislation, should not, Mr Chairman.
The Honourable Trevor Mallard.
Secondary legislation should not override primary legislation. And I ask Michael Woodhouse, the Honourable Michael Woodhouse, in the chair, whether in fact all of 2A to E and 3A to D have the effect within of giving the right to make secondary legislation which would override the provisions of the primary legislation. And I just want to ask, was that matter considered by the Regulations Review Committee? Because in my view, that no, it wasn't. Chris Bishop says it wasn't. I'm pleased that it wasn't, because I would have thought that we would have had a report from, I think David Parker chairs the committee, and sorry, David Cunliffe chairs the committee. Right. Well, I'm sure David Cunliffe would have seen that was inappropriate, and we would have had a report. And one of the questions I've got is what is happening within the processes of the House that the Regulations Review Committee did not look at the regulation-making powers in this bill. Because I'm sort of glad Geoffrey Palmer's still alive, because if he was dead, he'd be spinning in his grave. He would be exceptionally angry. I'm sure he'll be exceptionally angry when he's. I know I spent some time with Geoffrey on Sunday. He still attends this Parliament, sometimes by mistake, and I think it's fair to say that coming to the function celebrating 150 years of Parliament being in Wellington was a mistake for the Right Honourable Sir Geoffrey Palmer, and he slipped away pretty damn quickly. But if he had, on his way out, had a look at this regulation-making power, he would have been absolutely outraged, because it's one of the things that we were taught Geoffrey, he can sometimes be a bit precious. He'd sometimes go, just a bit far. But there was some stuff that he told us that when we were backbenchers in the 1980s, and he was Deputy Prime Minister and Minister of Justice for much of that time. One of the things that he made absolutely clear to us is that you had primary legislation and the secondary legislation, which were the regulations, had to be subservient to that, and you couldn't amend the letter of the law passed by this Parliament by passing a regulation, and that's what this purports to do. And I just want to say to members opposite or members who are on the Select Committee, frankly, I'm sort of slightly grumpy with some of my own colleagues for not focusing on this, but I do, because. What? No, not focusing on the fax machine. Focusing on clause. I know that members might want to trip on to the clause past 68 and might want to focus on that one. But Mr. Speaker, 68, the validation of irregularities, is one which I think is very important, because, in my opinion, Mr. Chairman, because remember the heading of a clause is not part of the law. The heading of the clause is something which is not interpreted when it comes to the court. It is the substance, it's the lighter coloured words after 1, 2 and 3 are the actual, those together is the law that we are currently passing. That the heading is something which is not interpreted by the courts. And so while it does say validation of irregularities, actually the bits that we need to look at are the bits which say that the Governor-General may order the Council do any of the things described in subsection C. And most importantly, to validate anything done before or after the time required. Now, so anything done? To validate anything that is done before or after the time required? Does that mean if there's a package of votes which occur well outside the period, then that is, Mr. Chairman?
I call Dennis